A routine hearing suddenly turned into a tense legal showdown when Congressman Jamie Raskin pressed a top official over trademark filings tied to the mysterious Board of Peace. What started as questions about paperwork quickly spiraled into accusations of conflicts of interest, presidential favoritism, and abuse of authority.
It came up through several organizations about the cyber squatting, and the action needed to be taken to.
When you talked about the cyber squatting, you noted that there were lots of other organizations that were already using some variation of peace organization, peace committee, world peace, and so on, right? There are dozens of them. I mean, I found them this morning just on the way in.
Well, again, a reference was made to Shakedown. This was registered, this particular boardofpeace.org. And without that, you don't have the ability.
You registered that?
No.
Oh, who
a cyber squatter did. I mean, 8 minutes into.
But you don't have to talk about a cyber squatter. There are dozens of other groups that have peace in their name, right? Well, look, where does your legal authority come from to file trademark applications on behalf of this Board of Peace, whether it's a public or private group?
It comes from the combination of 35 U.S.C. 3 and 35 U.S.C. 2 under the Lanham Act and in your opening statement.
Well, wait, do you usually act as a custodian for the intellectual property rights of other entities, or is this just for President Trump?
This was to protect the name Board of Peace as the entity gets booted up, to act as a custodian in a very narrow capacity with a bona fide intent to use the name, and then it's a intent to use application.
Who has the bona fide intent to use it?
The USPTO.
The USPTO, what are you going to do with it?
In the very limited services that we define there, which is fraud, prevention, misuse.
But is that a service you offer to all American citizens? In other words, if I'm thinking about maybe creating a group one day and we might want to have a trademark and I'm afraid somebody else has a competing trademark, you will go ahead and file the application for me?
My responsibilities are, again, under 35 U.S.C. Section 3 to advise the president on matters of national security.
So this is a matter of national security? Okay, let me ask you this. You've emphasized today, and rightfully so, the importance of people who are applying for patents or trademarks to pay a fee, because yours is a fee-paid office. How much does it cost for someone to seek a trademark? When you applied for that trademark for the Board of Peace, how much does that cost?
It's not an expensive fee, depending upon.
The website says $350. Is that right?
Generally, yes.
It's not expensive. Okay, and one of the able lawyers on my staff just passed me this, you filed a petition on January 21st, 26 to waive that fee for the Board of Peace. Then you granted that petition the very next day, which underscores the bizarre conflict of interest you're in, now acting both as a representative of the Board of Peace and also the trademark office that's going to pass upon the petition. But why did you seek a waiver for the $350 for the Board of Peace, and why did you grant it?
The waiver was sought under the particulars of the intent to use application as the custodial filer, and I did not grant my own application.
Well, your signature, as I'm reading it, you filed this on the 21st, and then you approved it on the 22nd.
Well, I would like to see the document to which you're referring.
Okay, we will get you those documents. Are you saying you would not have approved it had you seen it?
I'm saying I don't recall this particular situation.
Okay, but
I do believe it's in
your
my authority.
signature.
Yep.
Okay, it was approved by Dan Vovanisi, but your signature is on the petition. And I guess,
yes.
Why did you request that waiver of the $350 payment for the Board of Peace?
Again, given that this is going to be an international organization, given the situation with the intent to use and the bona fide limited scope that we had, I made that petition just as I signed the application, and it was granted.
Okay, and then finally, you know that the Lanham Act forbids anyone from submitting an application unless they're the owner of the mark or the legal representative of the mark. So were you representing yourself as the owner of the mark or the legal representative when you filed the petition?
No, we are very clear. It's on a custodial basis. We are not the owner. It will be transferred to the entity once it's formed.
Okay, well, you're listed as the owner on the petition, both for the waiver and also the application. So, I mean, that's the way the Lanham Act works. In other words, if I'm asking for your advice, could I get another company to apply for a trademark for me? What's the answer to that?
If you're the President of the United States, yes.
The President of the United States could have somebody else. The President of the United States has tons of trademarks. So you're saying that he doesn't have to submit himself? Where does it say in the Lanham Act that the President of the United States is exempt from the general rule that you cannot have a third party seeking an application on your behalf?
I'm, again, directing you back to USC 35 USC Section 3, where it's the Undersecretary of Commerce and Director of the Patent Office shall advise the President on national and certain international intellectual property policy issues.
Those are matters of public policy. They're not questions of representing the president before the trademark office, which obviously creates a stark conflict of interest.
The gentleman's time has expired, but you may answer.
Sir, I was not representing the President of the United States in this regard. I was representing filing an application to address the cyber squatting issue under my authority under 35 U.S.C.
I appreciate it. Thank you. I yield back, Mr. Chairman.
Thank the gentleman.
This hearing exchange grabbed attention because it blended legal technicalities with explosive political implications. Congressman Jamie Raskin zeroed in on a controversial issue involving trademark applications filed for something called the Board of Peace. The central question sounded simple on the surface: who authorized these filings, and why was a government official personally involved? But as the questioning continued, the answers became increasingly complicated, creating one of the most uncomfortable moments of the hearing. Raskin repeatedly challenged the official over whether he was acting as a lawyer, a government representative, or something else entirely. The witness defended his actions by saying the filings were made to stop cyber squatting, claiming someone rushed to secure domains related to the newly announced organization just minutes after it was publicly mentioned. But Raskin wasn't satisfied. He argued that the situation raised major red flags because the Board of Peace didn't even appear to formally exist yet, making the government's involvement look highly unusual. The tension escalated further when Raskin focused on what he described as a potential conflict of interest. According to the discussion, the official not only helped file the trademark paperwork but was also connected to the office responsible for reviewing and approving it. That sparked accusations that the normal rules may have been bent. Raskin repeatedly returned to the same point. Would an ordinary American citizen receive the same treatment, or was special access being granted because the issue involved President Trump and a politically connected initiative?